People, let's get together. Stop all this fussing and fighting. Let's love one another. You gotta help your mother, help your father, help your brothers, help your sisters, help your neighbors and your friends. We are one people, one nation, one destiny. Everybody, y'all. One people, one nation, one destiny. Yeah, yeah. Separated. Now we are freer. That's the way it should.
All right. Hey, guess what? Good morning for those of you. As we have been saying, we will carry the court hearing concerning the elections petition, one of the elections petitions, and we will see how it goes this morning. We have attorneys at law, Roysdale Ford, senior counsel, and Selwyn Peters. They are the defendant lawyers, and they will be arguing a very strong case, and a case that is ought to be on the winning side of things based on the evidence. So spread the word, share the link, and that will be coming up at in just about 10 minutes or so from now. But I just want you guys to be warmed up, to be prepared, get your coffee, call your friends and let them know that we are on. A lot of you have been asking about the elections petition, what's happening. You haven't been getting a lot of information from where you should have been getting the information, but instead we give you the information right here on 107.1 FM because we do believe it is important. We believe that the elections petitions should be heard expeditiously. Unfortunately, in Guyana, that is not the case at all. And so let me just take the time out to say good morning to, we have the time, so we will say good morning to you guys. Simone Greaves, good morning. And then we have Charlin, I've got to pronounce people's names correctly, all the way in Atlanta. And some folks who don't know what ATL means, maybe they would think it's Alverston on the quarantine, but it's Atlanta. But if you're in Alverston on the quarantine, you can pretend, yes, that it's part of Atlanta. Good morning to folks on the quarantine and folks in Linden, all across Guyana. Those beautiful people in Georgetown. I know a lot of you have been praying for the country. It takes more than just prayers, right? Because, in the good book, it says prayers of, work without, prayers without work, is death, right? You've got to pray, and you not just got to pray and stop praying. You can't say, oh, Father, Lord, help us rid the nation, rid Guyana of those corrupt, illegal folks who are in office and say amen, and that's it. You've got to work. You've got to put on your boots. You've got to go out there. You've got to get things done, if you know what I mean. And when we say get things done, we're talking about ensuring that your constitutional rights are respected and that you are guaranteed these things in the Constitution. don't allow the PPP or the cohorts to tell you what you should do, when you should protest, when you shouldn't protest, and these stuff. I don't know. Colin Williams. Good morning to Colin Williams, all at Arokaka. You got to be careful how you pronounce. Hey, Guyana has some names. You just I don't know, Karakaka, Arakaka. It's a it's to me it's an Arawak name. I don't know what Arakaka means, but Colin Williams is in Arakaka. Good morning. Again, coming up at 9:30, we'll be carrying the elections petitions appeal, and that is being done. Appeal. It's being done in the appellate division of the Guyanus Court, and we want to hear exactly what is going to be coming out of that. Um, a little bit of optimism, I'm hoping, because usually when you look at the decisions and the makeup in terms of whether three justices, there's always a 2 to 1 and something. And when you look at the makeup as to the who is the one, right, or who are the two, it tells a lot about Guyana and in terms of our independence, in terms of judicial independence. As you all should know by now, that Guyana, we have, just like the United States of America, three branches of government. And the three branches are the executive, the legislative, and the judicial branch. And all three branches ought to be independent of each other. But in Guyana, it seems as though it comes under one Guyana, one umbrella, just like they're pushing the one card uh, system now, the one card, all these different things. When you talk, right, and you ask those who are being paid to do work for you, the opposition, some people get vexed, they get upset. They feel, Mark, you're a little too tough on the MPs, and you've got to be tough on these guys. This is not, we go into church and we just grab and pray. This is a politics. You've got to be tough. You've got to be thick-skinned. You think it's 2 cents things said about me? And I'm not an elected official, right? But yet I'm here still. These politicians, these opposition politicians are members of parliament. They got to realize that people don't hate them. People don't hate them, and they shouldn't be in this game for people to love them and to people to click on like and this and that. They must be corrected, and they must realize what the majority of people are saying. I don't know. Rhonda Lane, good morning to you. Good morning, Rhonda Lane. Rhonda Lane. A nice woman. I'm not sure I met Rhonda Lane in person. Maybe we did, but I like her spirit. She's a fighter. I might not agree with everything she says or how she says it, just like you guys don't agree with everything I say. And, that's the world. But people are entitled to say what they have to say. The Constitution gives them that right. The freedom of speech. Wait, is only Jack Day and the likes of Irfan Ali could speak whenever they want, whatever they want, and nobody else can do that? I don't know. Rhonda, good morning. I tried calling you, Rhonda, but you ain't picking up your phone. I don't know why you're not picking up your phone. I'm going to try to call you now so that I can say good morning to you live right here on 107.1 FM. Please pick up your phone, Rhonda. I'm going to call you now just to say good morning to you and to say that you have a lot of people. People are not going to get caught up in throwing you under the bus. We're not going to throw you under the bus, Rhonda. You're a fighter. You're out there. Whenever a protest is called, however small it is, you are out there. You put your little purse over your shoulder. You jump in your minibus and you go out there to get things done. You are a good community organizer. Don't have anybody tell you otherwise. And I'm not going to throw you under the bus because of something you may have said, which is your opinion. That is your opinion. People are entitled to their opinions. And it's ironic how some folks who are very, very quiet, and a bunch of atrocities, a bunch of things happening to people, they're very quiet about it. But as soon as Rhonda or somebody looking like Rhonda opens their mouth, they rush to condemn Rhonda. I'm not going to condemn you, my sister. Again, I don't necessarily agree with everything, but what I do agree with is your constitutional right to express yourself. You have every right to express yourself. Every right to express yourself, just like others do. All right, coming up at 8:30, we have the elections petition. Our operator, we're trying to get on to Rhonda. We'll see what's going on. Good morning to Brenda. Good morning to Lex. Hi, good morning. Let's see here for a second. Do we have Rhonda with us? 1 second, guys. 1 second. Hi, Rhonda. Good morning. Can you hear me?
Yes, I'm hearing you. You hearing me?
I am hearing you loud and clear. Folks around Guyana and other places are hearing you loud and clear. And just before I let me ask them again to share the link for us, please, because coming up in just a few minutes, we have this live coverage of the elections petition. But before we get to that,
Okay.
Rhonda Lane, good morning. How are you?
I'm here.
You know,
I was just complaining about the protest because like by walking around for those amount of times with that is 1 or 2 hours like my heel. But that wouldn't keep me from going out to protest.
I just want to take the time out to salute you on behalf of almost everyone watching this program, because you're a brave woman. You go out there, you
Thanks.
protest. It doesn't matter. Once it's a protest to expose the illegitimate, the illegal, racist PPP regime, you are out there. You express yourself
yes.
in a very unique way. Sometimes I don't necessarily agree with everything, and you know that. And I don't expect everybody to agree with me all the time as well. But you're entitled to your views. What exactly you said that was so wrong? And what exactly you said that people are now saying that you I mean, you didn't say that people are now saying that you said. What's going on?
I was simply talking in Boston and I mentioned about lands. And what provoked me, what made me talk when you study that the regime is going into the African areas and taking away ancestral lands and doing what they want to do. Look, the latest one is with Peter's Hall. I understand Minister Ferguson, I think it is her, said that the people who first gave the sighting of the bridge, the landing of the bridge, Offer told them the best place was in Houston, and I think, I can't remember what part of the West Bank, but Georgetown was Houston. And they now remove sighting it in Georgetown. In Houston, they would not have had to remove so many houses. But they decided their own self that the eastern section of the bridge must be landed in Peters Hall and removing about 26 African people from the foot of the bridge. Now you're removing people. Then they did an evaluation to offer everybody a meager $20 million for their building. Now let me tell you, Mark, you got certain places where land selling from 5 million and may exceed 20 million. And then you're going to tell me within 2 months, I'm giving you $20 million. Take it or leave it. That is a slap in our faces. Now, after all of that, prior to that, the zinc huts that they're making to sell to people when you run it off, might be about $7 million. You cannot live in the sea. So I told the people, told them in the speech, it isn't right. And when you study that we Africans came from Africa, you look at the landmass that is Africa, part is to end up as South America, and you look at the landmass of India, whereas over 1 point something billion people, you could see the scarcity of land. And then I went down to talk about what I read and saw on YouTube and listened to Christian Amanpour. And I told them about the states that they were living in Calcutta, many of them. They would not have taken the rich ones from Delhi or Punjab province and the high-flown area to bring them here to work as indentured laborers. I said they would take from the low, because if you know, India is a place with caste, and you will not take the high caste to subject them to the low, to live as a low caste. So it was most obvious that it's the people from the low caste who are known to be living in this abject poverty place as Calcutta. They themselves said, Master said it was the slums. And I spoke about that.
So one second. So you were basically giving your opinion because of the fact that you are of the view that the regime, the PPP regime, the installed PPP regime, is taking advantage of persons of African descent. They're bulldozing their lands. They're doing all manner of things. And that has frustrated you to the point whereas you gave, in your opinion, a little history about where Irfan Ali and Jagdeo and those folks came from, and even some of our own ancestors came from in India, the slums of India. Yes. You were just giving a quick rundown.
I was giving a quick rundown.
Okay.
And not to say we're talking. Bharat went back to his hometown years ago as a president. I know that with all they would call the Africans, they tried to follow us. So he was following the paths of that man in roots. And when he went back to India, we all know he came back to Guyana and he brought the Zika virus. When he came back, he brought Zika to Guyana. Where did he get it from? He said he went to man. Oh, and man said the thing. At the time, the health minister was this man, Leslie Ramsamy.
So let's well, he probably did not more than just Zika, but why do you suppose, Rhonda, whilst we prepare, because there's a hearing coming up shortly, I noticed the attorney, one of the attorneys, Selwyn Peter, is with us. Good morning, good morning, Selwyn. And we wish you all the best, you and Senior Counsel Ford, all the best in this here. But why do you suppose that some of our Indian brothers and sisters, especially those in the coalition, caused them to issue a release, a swift release, rebuking what you said? Why do you suppose that they went that route to go after you?
Oh, well, they went that route because I don't know what to say with them. Now these things are happening constantly to the Africans in Guyana. They are supposed to be in an African party. And when I saw Yuvraj and Ganesh at the site in Moko, but they should have, to me, put aside those two. The rest should have been more vocal in their behavior towards what is going on.
Let me stick a pin. Good. I didn't mean to cut you. And let me just remind our listeners that coming up shortly, we have the live coverage of the elections petition. In the meanwhile, we're just chatting here with Rhonda Lane, a brave woman. You are saying that these folks were swift to attack you, but they're not as swift to go out to speak out against the atrocities committed against persons of African descent.
Of course.
Continue, please.
Now, what I'm saying, probably they thought that they claim that Leader Norton spoke immediately after me, and he did not try to like cushion what I say or polish it off. What none of them don't know, I am not affiliated to a party, no political party in the entire world. And I would give my views as I see. And if I want my poem was the six blind men of Hindustan who had to go and tell the world what they thought an elephant was. And they were each left different parts of the elephant, and they came up with their summaries. All of their summaries were right because they all described the complete elephant. So they're jumping up. They should have said, well, you know what? This thing with this woman said, we don't like it. Ganesh claimed my yard show, he knows me. Ganesh should have called me and said, man, run up. I want us to meet and let us sit down and talk. But let me tell you, ma, we as Africans, we had our history too. Because let me tell you, see, when the both meet in the assault way, there was, you know, business does go. The slave traders are the favorite plantation owners who used to come aboard on the ship and they take the best out of the lot. And they used to judge the men by the
I got you. We are on radio, we are on radio, so I just want to let you know that we are on radio. But go right ahead in terms of your depiction.
Yeah. And they used to check out what they want, and the best for looking good to them, they pay a higher price. The women were being beaten, pregnant in holes. Master used to sleep with all the women who they could see, black women, African women. We had our qualms with being in slavery. And I don't think an African will jump because they tell us that. That is our history. Our history is our roots. And if we don't know of our history, we will behave a certain way. But once we know our history, man, we will know how to behave in another time because of our history. So I spoke about all of our history.
But let me go on. And everyone, every ethnic group has a history. And Africans are not afraid to talk about the history in terms of what our ancestors went through for 400 plus years in building that nation. And you have described in terms of how our women were treated. We could have had more aunts and uncles and great cousins, great aunts, and all these different things. But because they were murdered, they were murdered, they were raped on the way to Guyana and other parts of the world. That is a painful history. And people must never try to reduce the history of our African ancestors and equate it to something as not even close to be. But let me ask you this as we prepare to go, though. Your statements, or whatever it is that folks are disagreeing with you, you are proud African, and they are. That doesn't make you anti-Indian, right?
No.
Go ahead, talk a little bit more.
Because, let me tell you, man, I have Indian friends, you know. I have Indian friends. And I will call a spade a spade. Look, I tell everybody now I work at the lumberyard. And one half, I just don't work late some afternoon. If you go in the afternoon, you don't come late. And this day I went further to the Chinese to buy something. So I dropped my bicycle in front of the lumberyard car to collect me tools with bucket and a piece of wood. Plum and a young Indian boy was coming up, and after he saw the bicycle on the ground and he saw me standing up, this boy, he said, Auntie, what do you? You sick? And this boy had so much of concern. I said, no. He said, you sure? A little Indian boy, you know. And I know what to do anyway. I cried. He stood up and go over the road and come back. I said, you could go, and this boy was walking in front of me. And all the time he kept looking back to see that this auntie okay. So they are Indian people who is being caught up with what is going on. I don't say some of them are not racial. I go and say, it's not black man, hungry belly black man, because we get that a lot. But when you put aside those, there are still some who will show you that type of thing, love, to show you at least we understand your pain, we feel for you, but, so you cannot paint all Indians with the same brush. And when it comes to their history, so many of them, because see, this girl Ragobir, she is very much thing, but instead of she jumping up on the high horses, she is a reporter. She can't get Christian Amanpour claim, because Christian Amanpour is half white, half Indian. And she is the person who did an expose on India to talk about certain things that I spoke.
We certainly have to go. I will invite you back for a longer period of time. We have the Court of Appeals, elections petitions coming up shortly. Rhonda Lane, thank you so much for your time. And you're welcome, Rhonda. God bless you. Yes, even if it's your boots on the ground alone, we salute you. We salute you.
The boots grinding out, you know.
We got to get your new boots. What size? 11?
Recording in progress. To the Elections Commission.
All right. We love you, Rhonda.
We submit your that the key issue in this case, which was overlooked by the respondents, is the difference between delegating authority to make subordinate legislation within the framework of a statute under which delegation is made, and assigning plenary legislative power to another body. In this case, Your Honor, it is submitted that it is not an issue simply of... All
right, guys, let's go to the elections petitions matter now. Share the link, spread the word.
Of plenary legislative power of a constitutional nature. Sorry, Your Honor. Section 61 of the Constitution of South Africa, which is the basis for the decision in which we rely on, provided that bills affecting the boundaries or the exercise or performance of powers and functions of the provinces shall not be deemed to be passed by Parliament unless passed separately by both houses, and in the case of a bill other than a bill referred to in Section 62, affecting the boundaries or the exercise or performance of the powers or functions of a particular province or provinces only, unless approved by a majority of the senators of the province or provinces in question in the Senate. The Supreme Court of South Africa ruled that this proclamation was unconstitutional, as it constituted legislation which affected the exercise or performance of the powers and functions of the province, and as such legislation was required to be passed by Parliament. We submit that the Supreme Court of South Africa does not only rule that the proclamation was unconstitutional because it constituted legislation to be required to be passed by Parliament, but that power to pass such legislation was conferred on Parliament by the Constitution of South Africa. In Kwang Wok's case, Your Honor, which is a case relied on by the other side, there existed no provision in the basic law, that is the Hong Kong's constitution, which vested the Legislative Council with a specific power to enact legislation in question, that is in relation to the Emergency Regulations Ordinance, which was the subject in that case. As the Court of Final Appeal stated in paragraph 37 of its judgment, the only issue raised under the impermissible delegation argument, and I quote from that provision, from that paragraph, is whether in truth and in substance, the ERO is a piece of legislation which seeks to delegate to the CEIC general legislative power to make primary legislation, in which case the ordinance is unconstitutional, or whether it merely authorizes the CEIC to make subordinate legislation in times of emergency or public danger, in which case the ordinance cannot be challenged on the present ground. The Court of Final Appeals of Hong Kong stated that it was a question of general legislative power, as opposed to any particular special constitutional, legislative, or plenary power. The Emergency Regulations Ordinance, Your Honor, was enacted in Hong Kong pursuant to Articles 8 7 and 731 of their basic law, which dealt with a general legislative power and the power of the legislative council to enact, amend, or repeal laws. In the instant case, in our situation, Guyana, the Parliament was conferred with the power to pass laws by Article 163A4 to deal with the manner in which elections are to be held pursuant to paragraphs 161 and 2 of the Constitution. It is clear, we believe, Your Honor, and we submit respectfully, that this Parliament, it was given the power by the Constitution to pass laws dealing with the manner in which elections are to be held. Section 22 of the Election Laws Amendment Act, we respectfully submit, thus represents an encroachment on the provisions of Article 163A4, as it was a provision which gave and conferred on the Elections Commission the power to amend or modify the manner in which elections are to be held in respect of elections being held pursuant to Articles 161 and 2 of our Constitution. The provision in Section 22 states, Your Honor, if any difficulties arise in connection with the application of the Act, the Representation of the People Act and the National Registration Act, we submit, Your Honor, that the reference to this sentence here constitutes the occasion for the exercise of such powers for the removal of such difficulties. Such exercise of such powers permits the Elections Commission to determine the manner in which elections are to be held pursuant to Articles 161 and 2 in a manner not contemplated by the Constitution. Such exercise, Your Honor, to determine the manner in which elections are to be held is a power given to Parliament specifically by constitutional provision to be done by an act of Parliament in accordance with Article 170 of the Constitution. We therefore submit, Your Honor, that Section 22 is a law inconsistent not only with Articles 163 and 4 of our Constitution, but Articles 170, and Article 8 of the Constitution, and can be of no legal force or effect. Our situation, we respectfully submit, is very much like the case of the Executive Council's case, where their Parliament could not permit another body to exercise its legislative power when it was required by the Constitution to enact specific legislation, for example, in relation to those provisions which I've already referred to in the Executive Council's case, and in the same manner in the instance case, the manner in which elections are to be held and conducted. Additionally, we submit, Your Honor, the exercise of Parliament's legislative power, as required by Articles 163A and 4, requires an act of Parliament, which itself determines the manner in which elections are to be held pursuant to Articles 161 and 2 of the Constitution. As we've submitted, Your Honors, Section 22 is not an act, is not such an act, as it does not determine the manner in which the elections are to be held pursuant to Articles 161 and 2, but permits the Elections Commission to determine the manner in which elections are to be held pursuant to Articles 161 and 2. In light of Articles 163A4, conferring constitutional specific power to determine the manner in which elections are to be held pursuant to paragraphs 1 and 2 of Article 160, we respectfully submit that this case falls under or within the boundaries or limits or the proposition of the Executive Council in circumstances, and not that of the Hong Kong Wing Hang case. The constitutional conferral of constitutional plenary power in Executive Council, like in the instance case, Your Honor, we respectfully submit, distinguishes it from the Kwong Wing Hang case. We respectfully that case, the Kwong Wing Hang case, ought not to be considered neither as applicable or relevant in instance circumstances. Your Honors, it is submitted that not only that Parliament has an exclusive authority conferred on them by the Constitution to determine the manner in which elections shall be held, pursuant to paragraphs 161 and 2 of our Constitution, but that Parliament cannot divest itself of such a power as it purported to do by enacting Section 22 of the Election Laws Amendment Act. It is submitted, Your Honor, that Parliament cannot confer the power to amend or modify legislation on the Elections Commission. Your Honor, we refer to the case of Mulcreevy against the Minister of Environment and Heritage and Local Government, a decision of the Supreme Court, I believe, of Ireland, in which case, Your Honor, a provision specifically provided of the Section 9 to the Ministers and Secretaries Act of 1924, provided it shall be lawful for the government by a minister to transfer, to confer and impose on any minister any of the jurisdiction, powers, bodies, and functions of a board of commissioners or statutory body. In response to the issues raised in that case, Your Honor, the court held, and I quote, "It is well established that the exclusive role assigned to the Richters, that is the Irish Parliament, in the making of laws by this article does not preclude the Richters from empowering ministers or other bodies to make regulations for the purpose of carrying into effect principles and policies of the parent legislation. But it is also clear that such delegated legislation cannot make, repeal, or amend any law, and to that extent that the Parent Act purports to confer such a power, it will be invalid having regard to the provisions of the Constitution." Your Honor, we rely also on the Irish case of McGowan against Labour Court, in which the Irish Supreme Court drew an important distinction between the constitutional systems with a written constitution and those where the Parliament is supreme. The Irish Supreme Court stated, Your Honor, that in a constitutional regime where a Parliament is supreme, any provision may be made, including presumably the power to delegate other parts of its lawmaking functions. But it is worth recalling, however, that in the constitutional dispensation created in Ireland, the position is somewhat different, and we respectfully submit it is the same situation in Guyana. If in truth any piece of regulation amounted to a truly delegated legislation, it would offend Article 50, since it is plain from the very language thereof, and indeed the constitutional structure, that the function of legislation is one that cannot be delegated by the Richters to any other body. We respectfully submit also, Your Honor, in relation to Section 22, that Section 22 is invalid and unconstitutional, in that it fails to provide statutory guidance on a number of material matters. First, the preconditions for the exercise of the powers purportedly conferred and/or transferred on the Elections Commission, and secondly, the content of the exercise of the powers purportedly conferred. Section 22 permits the Elections Commission, Your Honors, to define its principles for when and how the power is exercised. Section 22 offers no guidance as to the preconditions. In the McGowan's case that I had referred to earlier on, the Industrial Relations Act of 1946 of Ireland allowed the trade unions and employees to register employment agreements, the REAs, which they would have entered into. And once registered, they would apply as a standard term across the particular sector. The question for the Irish Supreme Court in that case was whether the trade unions and employers were excessively empowered by the legislature. Section 27.3 of the Act, which provided for the registration of these agreements, said that it must be made subject to the satisfaction of several preconditions. And I draw Your Honor's attention to two of them. The parties to the agreement are substantially representative of workers and employees, and the agreement is not intended to ensure or protect the retention or insufficient use of costly machinery and methods of work. Your Honor, the court stated in that case, Your Honor, that subparagraph C does contain a condition, but it does not set out any principle or policy for the content of that agreement. While it is directed towards the labor court, it provides no guidance on something that might be considered fundamental, being the representative nature of an agreement, which will have the effect of binding persons who are not parties to it. It is submitted, Your Honor, that the statutory guidance as to what, I submit, Your Honor, that it must be statutory guidance as to what these preconditions mean. In McGowan's case, the court stated in paragraph 30 that no guidance or instruction is given to the labor court as to how the matters of representativity or restriction in employment or inefficiently or costly methods are to be engaged. In the other case that we relied on, Your Honor, Lowenfield against Minister of Justice of Ireland, the court stated, Your Honor, that there is a precondition that must be laid down. The court said that the minister must use the power properly, and the court found that the preconditions, which I refer to at paragraphs 36 of my written submissions, must be set out specifically. The court stated, Your Honor, and I quote, "One searches in vain to find principles and policies regarding the deportation of aliens in the act. The legislature grasped the power over aliens from the executive and delegated inadequately to the minister. It abdicated its power. We submit that this case, Your Honor, is very similar to the McGovern's case and the Lowenfield's case. We respectfully submit that it must not only be a precondition, but it must be statutory guidance as to what the condition means, so that there may be a sufficient limitation on the regulation-making power granted by the statute to render the regulation no more than filling in of gaps in a scheme established by a parent statute," end of quote. We respectfully submit, Your Honor, that the Section 22 offers no guidance as to the content of the powers given unto the Elections Commission once those preconditions are passed. Your Honor, we rely on the case of David and Sheehy, in which the court stated, Your Honor, that there are no principles or policies contained within the Act. Section 1 states broadly that, quote, "the government may by order," which is similar to our case here, Your Honor, "do a number of things, which is to impose a customs duty or excise duty of such amount as it thinks fit on any particular description of goods." The court stated, Your Honor, that in my opinion, that is reference to the court. The power given to the government here is a power to legislate. It is left to the government to determine what imported goods are to have custom or excise duty imposed on them, and then to determine the amount of such duty. And the government is left totally free in exercising this power. It is far from a case of the government filling in only details. The fundamental question in regard to the imposition of duties on the imported goods is first, on what goods should the duty be imposed, and secondly, what should be the amount of the duty. A decision on both these matters is left completely to the government. In McGovern's case, Your Honor, the court commented on the content of powers set out in the act that we had already referred to. The court stated, Your Honor, that an REA can make provision not merely for remuneration, but can make provision for any matter that is be regulated by a contract of employment. It is a delegation of a most fundamental and far-reaching kind. The court observed, Your Honor, that this is not a grant of a power to make regulations over a limited area subject to explicit or implicit guidance. It is an unlimited grant of power in relation to employment terms. No direct statutory guidance is given for the exercise of that power. On its face, the Act of 1946 does not impose any limitation on the content of such agreement other than that it should be conditions relating to employment. Your Honor, the nature of Section 22 itself, Your Honor, we respectfully submit it that, having regard to how it is drafted, that it can fall into the category, and it does fall into the category of what are referred to as King Henry VIII clauses. These clauses, Your Honor, refer to a delegated power under which subordinate legislation is given to enable them or the authority upon which it is conferred to amend primary legislation. It is submitted, Your Honor, that whilst these are common clauses to be found in English law, that the use of such clauses in the constitutional system of Guyana is unconstitutional. Henry VIII clauses have been stated to be consistent with parliamentary sovereignty, and we refer to the academic article in which this point was made at page 6 of footnote 12 of our submissions. We respectfully submit that the English constitutional system has evolved from a different system of separation of powers, from the separation of powers provided for under our Constitution. And it is this that makes or renders the use of King Henry VIII clauses in our system unconstitutional. Your Honor, we refer to the cases of Skerritt and Defoe and a number of other cases which establish clearly the supremacy of the Constitution and the need and the obligation on Parliament to act intra the Constitution in relation to the exercise of its legislative powers. And that is at paragraphs 48 to 54 of our submissions. In reply, Your Honor, we submit that the fundamental difference between the two systems of the separation of powers, of what Professor Dicey referred to as parliamentary sovereignty, as meaning Parliament, I quote, has the right to make or unmake any law whatsoever, and further no person or body is recognized by laws having a right to override or set aside the legislation of Parliament, is what permits and gives effect to the King Henry VIII clauses and to their validity in parliaments in which Parliament is supreme. So the power to enact the clauses, Your Honor, is for the purpose of to make any law whatsoever, including a law which permits the executive or any other authority to amend primary legislation. We submit in Guyana, however, the Guyana Parliament does not have the power to make any laws whatsoever, and it must act subject to the constitutional system of our country. Your Honor, we submit that the court did in fact find that the representation of the People's Act was modified by Order 60. This is despite the arguments now being presented by my learned friends that the court did not find that it was modified. Your Honor, strange enough, I believe it was the fourth name respondent that argued on the last occasion that the legislation was neither amended nor modified, and that the power to do what the Elections Commission purported to do was found particularly in Articles 162 of the Constitution. At paragraphs 90 of the judgment, Justice George specifically rejected this argument and felt that Articles 162 could not specifically confer any power on the Elections Commission to empower them to act as they did, and they needed to act on the basis of Section 22, even though she found it unconstitutional. And that is why, Your Honor, on the last occasion I pointed out that there was no appeal filed against the finding of the learned Chief Justice that Articles 162 was not a sufficient basis upon which the Elections Commission could have acted on alone. Your Honor, in relation to the issue of the modification, we respectfully rely on the judgment of Bose J. in the Reed Delhi Law case, 1951, Supreme Court of India, 747. Your Honor, in this case, the court posited the term modification does not necessarily mean a change in policy. It means an alteration in the permissible limits set by policy. We respectfully submit that the power to modify legislation is part of and a facet of the full plenary powers of Parliament. And in the context of Articles 162, it will constitute 160 of our Constitution. It will constitute a conferral of that sort of power to determine the mode in which an election is to be held. We urge the court respectfully, Your Honor, to adopt the meaning of the word modify as found by the court, the Indian Supreme Court. The court noted, Your Honor, and I quote two short paragraphs, that the learned Attorney General contended that the word modify, according to the Oxford Dictionary, means to limit, restrain, assuage, to make less severe, rigorous, decisive, to tone down. It's also given the meaning to make parties changing, to alter inherent radical transformation. On the other hand, in Roland Garros' Words and Phrases, the word modify has been given as meaning to vary, extend, enlarge, limit, or constrict. And it held that modification implies an alteration. The court, Your Honor, the Indian Supreme Court, established a number of propositions, Your Honor, in relation to this concept of modification. The court held, firstly, Your Honor, that the dictionary meaning of the word modify is to make something less severe, or to tone down, or to make partial changes in it. What modifications are to be made in a statute, or whether there are any necessary to be made, is an exercise of lawmaking power already conferred by the statute. And that is why we respectfully submit, Your Honor, that this power is traced directly to the provisions of Articles 160, 1, 2, and 3 of our Constitution. And that was a statement by Patanjali Sastry in the judgment in the Reed Delhi Laws case. Secondly, Your Honor, the power to modify certainly involves a discretion to make suitable changes, but it would be useless to give an authority the power to adopt a law without the power giving it to make suitable changes. As stated in the early part of this judgment, unless the power of the provincial government is extensive with the power of the provincial legislature, it is difficult to see how it can have the power to modify a statute passed by the legislature. Modification of statute amounts to reenacting it partially. It includes the power to say that certain parts of it are no longer parts of the statute, and not a statute within X sections is now enacted with Y sections. The power of amending a statute or altering it cannot be described as ancillary to legislation, nor is such a power within the ambit of the doctrine of subsidiary legislation. We rely on these propositions of law, Your Honor, which I have called from the judgment of the Indian Supreme Court in the Reed Delhi Law case. We respectfully submit, Your Honor, that an examination of the representation of the People Act would reveal that it was a legislative policy as reflected and as stated in the Act, that there was no policy to have a recount as conceived and or as executed by the GCOM. We submit, Your Honor, that GCOM conceived and executed as a policy was not an alteration which could have said to have been occurring or did occur within the permissible limits set by Parliament. The modifications by GCOM, made by GCOM, using the powers purportedly conferred on it by Section 22 of the Election Laws Amendment Act, cannot be said to be modifications as stated by Fazil Ali J. in Delhi Law's case. That is to say, modifications are to be made within the framework of the Act, as they cannot be said to have affected its identity or structure or the purpose essentially served by it. It is submitted that the use of Section 22 by GCOM to conceive and or execute a recount, where none was provided for the representation of the People's Act, constitute an alteration and or a modification of the structure of the Act and the content of the Act. It is submitted that the very formulation as set out in Section 22 itself is indicative of Parliament's abdication of its powers. Mahanjan J. Your Honors, in Reed Delhi Law case stated that moreover, abdication by a legislative body need not necessarily amount to a complete effacement of it. Abdication may be partial or complete. It would certainly amount to abdication when it is in respect of a subject of legislative list. That body says it shall not legislate on that subject, but would leave it to somebody else to legislate on it, as occurred in this case. That would be that would be delegation of the lawmaking power which is not authorized. There is no justification for the assumption that the expression abdication is only applicable when there is a total effacement or extinction of a legal body. In my opinion, in the abdication of the power to legislate when a legislature refuses to perform its duty of legislating on a particular subject and entrust somebody else to perform it, is abdication. Abdication amounts to abdication according to the Oxford Dictionary means abandonment, either formal or virtual, of sovereignty or other high trust. It is virtual abandonment of high trust when the person charged with the trust says to someone else that the functions entrusted to him in part or whole be performed by that other person. End of quote. We respectfully submit, Your Honor, that by the Constitution of Guyana, Parliament and Parliament alone is vested with the power to legislate in respect of the electoral system and under which elections are to be held. We submit that the conferral of such power on GCOM, the power to issue orders, to modify electoral laws, where in the opinion of GCOM, there is a difficulty in the application of electoral laws, constitute an abdication of part or portion of the constitutional authority conferred on the Parliament of Guyana by the Constitution to pass laws in accordance with Articles 65 and 170 in respect of the electoral system. Your Honors, having regard to the conferral of power on Parliament by the Constitution to make laws specifically for elections, it is submitted that such a conferral was in respect of, and I quote, a task specifically contemplated and conferred on Parliament, entrusted to it and to it alone, and to Parliament alone. Your Honours, in the course of the presentations of my learned friends, the Honourable Attorney General relied on the judgment of Sachs J in the Executive Council's case. I respectfully submit, Your Honour, that his reliance is misplaced when a regard is had to what actually that distinguished judge said in that case. Your Honour, Sachs J stated, Your Honour, and I quote for the benefit of my presentation, and I quote, "The question at issue does not seem to me to be one of the manner and form in which Parliament acts or the extent of its powers, but rather its capacity to delegate any authority, which it undoubtedly has. The Constitution contains no express limitation on the power of Parliament to pass a law, delegating its legislative authority. If we look at the design and structure of the Constitution as a whole, however, I have no doubt that such a limit must be implied. Indeed, it flows from the very majesty of Parliament, not from its impotence. Certain tasks are entrusted, and to it alone. Parliament has not only extensive powers, but heavy responsibilities under our Constitution. It is a centerpiece of our whole governmental structure, end of quote. At paragraphs 205, Your Honours, Sachs J stated that the fundamental purpose of Parliament, of its design, must be considered. Sachs J stated, and I quote, "The reason why full legislative authority within the constitutional framework mentioned above is entrusted to Parliament and Parliament alone would seem to be that the procedures for open debate, subject to ongoing press and public criticism, the visibility of the decision-making process, the involvement of civil society in relation to committee hearings, and a pluralistic interaction between different viewpoints, which parliamentary procedure promotes, are regarded as essential features of the open and democratic society contemplated by the Constitution. It is Parliament's function and responsibility to deal with the broad and controversial questions of legislative policy according to these processes." Your Honours, at paragraphs 206 and 207, Sachs J stated, "To my mind, what have been considered in relation to each act of Parliament purported to delegate lawmaking authorities is whether or not it is involved a shuffling off of responsibilities in the nature of a particular case and in special circumstances, and bearing in mind its specific role that Parliament has, should not be entrusted to any authority." But Sachs J proceeded at this point, Your Honor, to lay down certain matters. He said these would include an evaluation of factors such as the following: A, the extent to which discretion of the legislative authority is structured and guided by the Enabling Act. B, the public importance and constitutional significance of the measure. The more it touches on questions of broad policy and public importance and controversy, the greater the need for scrutiny. C, the shortness of the time period involved. D, the degree to which Parliament continues to exercise its control as a public forum in which issues can be properly debated and decisions democratically made. E, the extent to which the subject matter necessitates the use of forms of rapid intervention which the slow procedures of Parliament would inhibit. And F, any indications in the Constitution whether as to whether itself such delegation was expressly or impliedly contemplated. Your Honour, Sachs said these items should not be considered, in his view, to be regarded as a checklist to be counted off, but interactive factors which would have to be balanced against each other, with a view determining whether or not the delegation in the circumstance was consistent with the responsibilities of Parliament. None of them, it should be emphasized, permit Parliament to infringe fundamental rights, violate protected spheres of provincial authority, or in any other way deviate from the constitutional framework within which Parliament must function. Delegation takes place within, not outside of the constitutional framework. But even within that framework, it can be unconstitutional if it fails to satisfy the above criteria. End of quote. Your Honor, applying the above criteria formulated by Saxton, it is submitted that with regard to Section 22 of the Election Laws Amendment Act, the discretion of GCOM is not structured and guided by the Act, as I previously submitted earlier today. Further, we submit the empowerment of GCOM as provided by Section 22 in the Election Laws Amendment Act is in respect of a matter of great public importance and controversy. Significantly, as in the instant case, once Parliament would have been dissolved, the Parliament does not retain any continuing control over the exercise of the powers conferred on GCOM by Section 22 of the Election Laws Amendment Act. Your Honor, this was a specific factor identified by Saxton. We submit, Your Honor, that once Parliament is dissolved, it no longer can be considered an effective institution which can function as a public forum in which issues can be publicly debated and democratically made. Parliament
our section 72 does not give that power altogether. After Parliament is dissolved, isn't that the case that the power is only for 3 months, exercisable after election?
Yes, Your Honor. But Your Honor, in this case, Your Honor, after the particular order that has been made, or the 6th day, Your Honor, would have been made, practically, Your Honor, the effect of it is that during that period, the decision made by Parliament, Your Honor, it is not the sitting Parliament at the time that determines the effect of that law, Your Honor. For example, in this case, Your Honor, Parliament was in abeyance, it was dissolved, the Elections Commission purported to exercise the power. They brought in place an electoral system, brought in place a scheme, I refer to it as a scheme for the conduct of a recount. When that is completed, Your Honor, there's nothing that Parliament can do to correct that, Your Honor. Because the Constitution itself says that in relation to anything done by the Elections Commission, it is dealt with by an election petition. So, Your Honor, once Parliament would have gone into dissolution effectively, even during the 3-month period, and when we examine what happens after the 3-month period, there's nothing that Parliament could pass a law to say at that stage that what the Elections Commission did was unlawful. It will have no impact here because it could only be resolved and dealt with by an election petition brought by the courts and not by Parliament.
And isn't that a form of control too? Statutory control in the sense that it's only given 3 months period, and if it exceeds, the parties can bring this matter to court, whether by election petition or otherwise.
Yes, Your Honor, but my understanding of the principles, Your Honor, is that Parliament, when passing the legislation and providing for what is going to happen during that period when it is not, Parliament must be able to have continuous control, Your Honor, over the process in relation to the whatever legislation is purportedly brought into effect. And that is the problem, Your Honor, in the instant case. Your Honor, in the case of South Africa, that was one of the issues that the court identified as the need to have Parliament constantly capable of reviewing the actual law passed, Your Honor, and not ex post facto after the fact, Your Honor. And when we examine in the context of this situation here that is before the court, Parliament is no longer in a position to correct, control, or influence the legislation passed, delegated or otherwise by GCOM.
Look at it this way. Parliament cannot legislate for everything. And no one anticipated or no one knew that Parliament would not have been sitting at that point of time. So do you think that the legislature in its wisdom allowed that power to be delegated to cater for situations as the current one?
No, Your Honor. Your Honor, I believe that the legislation as contemplated by Parliament was to permit minor administrative, if I'm to go the way in which the question is asked, Your Honor, my understanding of the question is whether Parliament Section 22 to deal with this situation. And I'm saying, Your Honor, having regard to the nature of what...
Yes, and other situations.
To other situations. For example, Your Honor, there will be situations where there's a requirement to have a certain number of returning officers at a particular location. On election day, you may not be able to have all those persons present. You may not turn up for work. You may need to put in place some legal coverage or infrastructure to have persons go out and to man the elections at a short notice. Beyond, I believe, having regard to the fact of what happened in this case, Your Honor, where a recount was implemented and executed that was not at all contemplated or provided for in the law itself, rendered it a radical departure, Your Honor, from what I consider to be the mundane sort of ordinary or restricted sort of events for which this law could have been employed for. Having regard to the fact that, as Your Honor pointed out, Parliament in its wisdom may have considered that there is some need for it. I believe, Your Honor, having regard to what Sachs J said, having regard to the great importance of the impact of the recount and how the recount itself impacted on the entire electoral process, I don't believe that would be part of what would have been remotely considered as reasonable by Parliament. Your Honor, that is why Sachs J, Your Honor, found that the proclamations issued by the President of South Africa were unconstitutional because the proclamations were no longer subject to parliamentary control. He said that they must remain subject to parliamentary control. Your Honor, at paragraphs 209 of the decision, Sachs said, on the other hand, there's the glaring fact that Section 16A provides no clear guidelines as to how the President is to exercise his legislative powers. In the circumstances mentioned above, my view is that if Parliament had established clear guidelines, structured and not going beyond the principles contained in Sections 235, Section 16A would have comfortably passed muster. This would have been so even if such a provision had permitted the President to repeal laws. Then he goes on to say, the acceptable balance would have been maintained by ensuring that the extensive powers delegated could only be exercised for a short time according to the criteria laid down by Parliament and subject to parliamentary control. So I'm respectfully pointing out that parliamentary control was not existent in our situation. Parliament itself, divested itself of the parliamentary control. The Constitution, provided that at a certain point, Parliament's legislative capacity would be limited. The ability to recall Parliament was restricted by the Constitution itself, I believe, to emergencies, and that was not employed and relied on in this case, Your Honor, to recall Parliament to pass legislation dealing and touching with these issues here. Your Honor, we respectfully submit that the elections were not lawfully conducted. The evidence we respectfully submit point to the failure to conduct the elections in accordance with the representation of the Sixth People's Act, and that 640 had an effect on the elections. At paragraphs 119 of the judgment of the learned Chief Justice, she referred to the evidence before the court, but we respectfully submit, Your Honor, that having regard to that paragraph, the learned Chief Justice failed to have regard to all the relevant evidence before the court. The learned Chief Justice stated, Your Honor, Mr. Jeremy referred to a difference in the recorded figures for the parties as disclosed in two of the exhibits. Exhibit A, the official gazette of August 2020, in which the results are declared pursuant to Order 60, and Exhibit D, a letter from the CEO to the chairperson dated 11th of July 2020, with a report from the CEO regarding his tabulation of the result, to say that this shows that the result was affected by Order 60. With great respect, much more would have had to be produced than a mere suggestion from the bar table. It is unclear what was the basis of the CEO's report, as moreover, the court in CCJ and Ali against David had impugned a previous report submitted by the CEO dated June 30th, 2020. Your Honor, we submit that the Lord Chief Justice failed to have regard to Exhibits L and M in support of the affidavit of the petition. Exhibit L was a letter directed to the first respondent from the Chairman of the Elections Commission instructing the first respondent to prepare and submit a report pursuant to Articles 177 2B of the Constitution and Section 96 in accordance with the Certificate of District Tabulation from the National Recount. Further, the declaration of the results were made on the Recount Order Number 60 of 2020 as published in the Official Gazette of the 20th of August, 2020. Your Honors, the Court did not have any regard to Exhibit C, which is the electoral return of the returning officer of District 4, Form 24, as required by the Representation of the People's Act. The votes recorded in the electoral return district of Region 4, as well as the report submitted by the respondent to the Chairman of the Elections Commission, Exhibit D, are different in terms of the votes cast for the parties from the certificates of district tabulation upon which the recount was declared. We respectfully submit to Your Honor that it is therefore not correct for the Lord Chief Justice to have concluded that there was no evidence that the result of the elections, which is ascertained by the total of the votes cast as reflected in Form 24, the electoral returning officers, was not affected by the implementation and execution of Order 60 and the exercise of the purported powers conferred on GCOM by Section 22. The result of the election being affected by Order 60 and Section 22 is evidenced by the difference in the votes recorded in Form 24 of the electoral turn of District 4 and the votes recorded in the District Tabulation 4. Your Honor, we respectfully ask the Court to uphold our appeal here. Those are my submissions to this Court respectfully, Your Honor.
Thank you, Mr. Thorne. Any questions from Mr. Thorne? I mean, the panel at this time, or we go to the next party in this case?
I did have questions, but Chancellor, your questions touched on what I had been reflecting on as Mr. Ford spoke. I really was asking myself as I listened to Mr. Ford, so are we then to, as the court, to examine GCOM's decision that there had been a difficulty? Parliament had been dissolved. So is the court, if I'm understanding this Ford correctly, but was that not to proceed in the face of a difficulty which Commission identified, whether the court should really examine how the Commission should have resolved it? I don't know if I'm understanding Mr. Ford correctly, because he said it was more for mundane. Section 22 should have been more for mundane difficulties or mundane issues. So if as an agency with the responsibility under the Constitution to supervise and manage elections, if that agency within its powers finds that difficulty has arisen and it proceeds to resolve that difficulty in a way that it feels is consistent with what it has to resolve, or in a way that effectively resolves what has arisen, is the court to go behind that? If I'm understanding Mr. Ford. So is it then that the matter should have been referred to Parliament? And the GCOM should have explained what the difficulty was to Parliament? when GCOM was itself the constitutional agency tasked and vested with the powers to supervise the elections, aren't we drawing a very fine line as to how far GCOM could have gone in exercising its powers in resolving a difficulty, as against referring back to Parliament in a critical moment, which was the situation here. So I really clear why Mr. Ford says that GCOM or the Parliament acted unconstitutional in passing Section 22.
Your Honor, could I respond, Your Honor?
Yes, please, go ahead.
Thank you, Your Honor. It is my respectful submission that Section 22 is unconstitutional for all the reasons that I would have advanced, Your Honor. Your Honor, the court has asked the question whether having conferred with the authority, the purported authority, to act where there are difficulties. It is my submission, Your Honor, that when that is examined, that it is unclear and vague as to what are those difficulties and the circumstances and the conditions upon which GCOM had to exercise those functions. My response, Your Honor, to the learned Chancellor as to what Section 22 meant was my understanding, Your Honor, that, and my respectful submission, that Section 22 is unconstitutional. I did not mean that answer to be a concession or a departure. It was just trying to speculate, in my opinion, as to in my speculation, not the court speculation, as to what could have possibly ever been meant, and to whether, in my opinion, whether this such a radical departure from the structure of the act could have been contemplated. And I was referring at that time of when I responded to the Lord Chancellor's question, I was responding to the probanda outlined by Sachs J, among which was the issue of continuing control of Parliament. And I was trying to point out, Your Honor, that this was a matter of great public controversy and importance. And in that context, I couldn't see Parliament being conferred with something so radical, especially having regard to the fact that what were the difficulties from a legislative point of view were not specifically provided, and they were left extremely vague. And that was one of the criteria, a standing criteria, which in itself would render Section 22 unconstitutional. And that is not because there were difficulties provided in the legislation necessarily rendered Section 22 a valid legislation. So it was in that context I was answering and not conceding as to the validity of Section 22 in any way.
All right, yes, Mr. Ford, but I still am not clear. What is your response to GCOM's position that particular crisis had arisen at that time?
Sorry, I'll answer that.
I'm not finished. A particular crisis had arisen, and as it turned out, GCOM made that determination as to how to proceed. So, and it made that determination, of course, under its powers under Section 22. That's one thing. So, are you saying then that GCOM should have deferred Parliament, or what? Or should it have gone back to the RPA, representation of the Act, if it felt that, in other words, you're saying GCOM should have found a way under the RPA? And what is your view on that?
Yes, Your Honor. I am not clear on the question. Respectfully, I apologize. Your Honor, I'll answer the question in two ways, Your Honor. Your Honor, in the original submission and in the petition itself, I pointed out that Justice Holder had ruled that the declarations made by the returning officers were valid and effectual and could only have been set aside by an election petition. That was a determination made by the High Court.
So Thorne, I don't know that you need to go back to those declarations because, no, Mr. Ford, I thought that those matters had come to this court and this court had adjudicated in any event. So
that matter, Your Honor, did not come to the appeal court, Your Honor, in any way. What happened, Your Honor, is that GCOM decided, having conducted the recount, and during the period of the recount, they put those statutory declarations into abeyance. I can't recall specifically, Your Honor, what is the legal status, whether they were ever set aside by GCOM, or what was the decision by GCOM in relation to those declarations made. The reason why I refer to it, Your Honor, because it's my respectful view, Your Honor, that Section 22 did not permit GCOM to act in the manner it did, having regard to the fact that declarations were made, found by the court to be lawful. The point I'm making, Your Honor, is that GCOM should have allowed the process outlined in the elections laws, Election Representation of People's Act, to run its course, and for those issues to be resolved by way of an election petition. So yes, Your Honor. Secondly, Your Honor, having regard to the fact that GCOM did not want to do that, it was open to them to approach the court for clarification. It was open to them to seek to have the Parliament's involvement in the matter. But I was pointing out, Your Honor, that having regard to the fact that GCOM could have gone back and acted in accordance with the representation of the People's Act, in terms of its limits and proportions set out in that act.
Mr. Ford, I don't want to belabor the point, but I think you've addressed it. The two options, if GCOM wasn't able to proceed under the RPA in its view, within its discretion as the agency with that responsibility, what was GCOM to do? You say GCOM could have gone to the court, say GCOM could have found a way to engage the Parliament once more, but that Parliament had been dissolved. In any case, you say that the Act provided means for GCOM to proceed, but I still feel that ultimately that was GCOM's responsibility, which it was vested as the agency to decide how it was going to deal with difficulties or the difficulty. Thank you.
But Your Honor, that would have been assuming that Section 22 itself represented a lawful exercise of power, because Your Honor, during the recount period, almost every court that the appellate, well, not this appellate, in which I was counsel, almost every court here indicated that these were issues that ultimately had to be resolved by way of an election petition, which petition is now before the court. So when GCOM, Your Honor, the constitutionality of the act of GCOM, I believe, must first be tested in relation to not whether the legislation existed to provide GCOM to act as they did, but whether the legislation, firstly, Your Honor, was lawful to which GCOM purported to act under. Thank you very much.
Thank you.
Very well. Justice Prasad?
Nothing for me, Chancellor.
Okay. So we go to the next council. I've lost track of the order.
So, Your Honor, the learned friends are being allowed to present again.
Well, if there's something they wish to say,
Okay.
to give them
Yes.
an opportunity in the interest of justice based
Yes.
on policy. As I believe on the last occasion, the issue was raised, but it would have been a roving commission. I think that opportunity would be given to clarify anything that is, if they're caught by surprise. So I think my recollection still holds. Any questions from council on the other side in relation to what Mr. Thorne has said, or that is?
Your Honor, speaking on behalf of GCOM, I don't think there's anything we can usually add. But I think I just want to make one comment, that the difficulties that was being experienced in Guyana and upheld by the respective courts, including the CCJ, were difficulties that prevented the declaration of the results of the election because of the misconduct or conduct of elections officers who were seeking, forgive the pun, to modify the results of the election to suit one side. That is what GCOM was confronted with, Madam Chancellor. Your Honor, I'm sorry. But we don't wish to respond.
Your Honor, in relation to the statement made by my learned friend, learned senior counsellor Astafan, esteemed counsellor as he is, the statement that there was a misconduct or conduct by electoral officers, there's no evidence before this court in relation to that, Your Honor. No affidavit was filed by the Elections Commission, and I believe that that is a most unwarranted statement by counsel at this stage.
I don't want to prolong the argument, Your Honor, but what I said was in effect a summary of some of the findings in the respective courts of Guyana and the CCJ.
Your Honor, there exists no case.
Mr. Thorne?
Sorry.
We wouldn't prolong the argument. We would leave it as it is. I take it that no other council wishes to say anything, and therefore,
I may just, Your Honor, if I may just, I don't have any further submissions to make because Mr. Ford was supposed to have been replying this morning, and the court had made it clear on the last occasion that he was restricted to a reply. I think it behooves me to point out that he has abused his right of reply, not only by repeating arguments that ought to have been made and were in fact made in his opening written submissions, but he had declined the opportunity to make any oral submissions on the last occasion. So he's now used the opportunity of reply to make submissions that he ought to have made initially. And secondly, in his written reply and in his oral reply, he has referred to a number of authorities that he had not previously cited, and he has not even provided us with copies of those authorities, a number of Irish authorities and Indian authorities as well. And that is not the appropriate place for a reply. So I'm not even in, if I wanted to, I'm not even in a position to reply to my learned friends that have authorities because he hasn't provided them to us. So I just wanted to make the point that ordinarily I would have nothing to say because my learned friend, if he stuck within the rules of a reply, he would simply have responded to our submissions and our authorities, and we would have nothing further to say. And Your Honors, I have nothing further to say.
Duly noted. Ms. Vera, Mr. Williams, Ms. Kissoon.
Your Honors, the Honorable Attorney General has no further submissions to make in response to the appellant's arguments. Thank you.
Your Honors, I have no arguments to make. I continue to abide the results of this matter.
Your Honors, Mr. Menes spoke on behalf of the fourth name for us, please. So we have nothing further to say.
Mr. Hero?
No, please, Your Honor.
Very well. Mr. Ford, did you see it fit to send copies of your additional authorities to counsel on the other side? And if so, why not? That being the practice of the bar.
Your Honor, I believe, Your Honor, they were sent. I have to check to see what the learned senior said was true, because I gathered the authorities, Your Honor, and I sent them off to the court, and I instructed the staff to send them off to all counsel in the chain. So I was a bit blown away by the statement about Mr. Bendez. The Indian Authority, for sure, Your Honor, was not a new case. It was a case that I had previously cited in the High Court, the Reed Delhi Laws case. It was a case that I had cited before, Your Honor. And certainly, Your Honor, even if there is a variation from the norm, counsel never contacted me to say indicate that, you know, we received your submissions without the cases. And these are cases, Your Honor, in any event, with minimal industry can be located on the website of the Irish Supreme Court.
No, it's the courtesies within the profession we're looking at.
Yes, Your Honor.
Yes, it could be located.
Yes,
if that is the case, an apology is required, Mr. Ford.
Certainly, Your Honor. I will take counsel at his word that it wasn't sent. But I see no reason why it should not have been sent.
We will consider the submissions of counsel, and we will be happy to send notices for decisions. The notices will be sent. Thank you all.
Thank you very much.
For the submissions, everyone. And please do continue to stay well and to take care.
Thank you.
Very much, Your Honor.
Most grateful, Your Honor. Beg to take leave.
Thank you very much.
George?
Recording stopped.
All right, that's the hearing there of the elections petition. Sorry about that. If you're now joining us, you just heard the elections petition there. One of the elections petitions being heard in the Court of Appeal in Guyana. Yep, and we're thankful that at least we got that opportunity to carry it live for you. And just to recap in terms of what's happening, the elections petition, you know, lots of questionable acts, but this is not what is being discussed currently. But I'm just merely reminding you guys as to what we have there right now in Guyana. A regime that is in office under questionable circumstances. Under questionable circumstances, and that is precisely what it is. We have heard there from Senior Counsel Roysdale Ford. Hopefully we will get some legal inputs as to what's the next step. I am not certain whether the counsel for the coalition will hold a press conference to explain to the general public and more so their support base as to what's the next move. I've noticed some questions here from folks. Where do we go from here? Where do we go from here? That's a legitimate question because the people don't want to be held in suspense, and then this matter just continues to go on up until elections. We saw what happened with the 1997 elections petition, where Barajak Jaya was in office for 4+ years until 2000, when the elections petition was finally adjudicated. And a decision was rendered by then sitting High Court Judge Claudette Singh, who deemed the then PPP regime on the Bharat deal as vitiated. And in March of 2002, that's when elections were held. And many are of the view that the March 2001 elections were actually won by the PNC, the PNC reform headed then by opposition leader and former President Desmond Hoyt. And then subsequent elections, we began to see the discrepancies, the blatant discrepancies and corruption at the Guyana Elections Commission. At the Guyana Elections Commission, we did see the 2006 elections, when there was a discrepancy with one of the seats in Region 10. And the PPP stole that seat. They knew that the seat was stolen. They knew that Sam Hines was squatting in that seat, but they never really paid any attention to that. They never really showed some sort of concern. So, and then the 2011 elections, we saw, again, there was an attempt to give Donald Ramotar a one-seat majority. There was an attempt, and they were caught again. And I say all of this because, oftentimes the PPP and their supporters love to talk about rigged elections. I'm giving you guys evidence. 2006 elections, in the minds of some Guyanese, it was rigged in favor of the PPP. In 2011, we saw a minority government headed by Donald Ramotar, and he swiftly broke Parliament because there was a no confidence motion being was hanging over his head, so to speak. So he broke Parliament and called fresh elections. We had fresh elections in 2015, and because there were eyes all over, it gave the coalition a majority. It just gave the coalition that majority until a snake just wiggled its way within the coalition and decided to vote in favor of a no confidence motion against a government that was repairing the dirty deeds and the dirty works of a regime that was in office for about 25 plus years, that destroyed Guyana at every level, the PPP. Some people, say after 20 something years, 26 or 25 years in office, they expected an overnight Dubai, so to speak. Cleaning up wasn't easy. It wasn't an easy task to clean up the mess of the PPPC. It was a heck of a mess. They destroyed the judiciary, they destroyed the police force, they destroyed NIS, they destroyed the private sector. You name it, everything they destroyed. It wasn't an easy mess to clean up. And in my opinion, some people who were tasked to clean up that mess should not have been in that position to clean it up at all, because they weren't even sure what they were cleaning up. But there were some who did a great job, and we know who those folks are. All right, reading some of your comments. We are reading some of your comments so that we. Sorry about that. We noticed there's a Guyana nowadays. Good evening to the folks at Guyana nowadays. And then we have. I'm just looking at some of your comments while we our operator try to see if we get a legal comment, because as you know, I'm not a lawyer, and I'm not going to sit here and pretend as though I'm a lawyer. Some people know that they're not lawyers, but when people call them lawyers, they do nothing to correct that. I am almost there, but I'm not a lawyer, not at least not as yet. So I can't call myself a lawyer. And in situations as such, you need lawyers to comment, people who are trained lawyers. We see here, we're talking about some other matters. Brenda Casey, let's see what she's saying here. Mark, after listening to Ganesh and Ramsarup, Ricky Ramsarup about protesting, I feel disappointed in Guyana's future. The opposition leader, Aubrey Norton, doesn't believe in protesting. So where do we go from here? Good question, Brenda. Good question. But I do believe that we have to not necessarily listen to those guys in the opposition. Aubrey Norton suddenly doesn't believe in protest. He doesn't want protest. He wants to be the church guy now. So he becomes the church guy and the strategist who always knows it. He's the church guy. So he's always strategizing. But I don't know what's happening in the coalition. It's whether there is still a coalition, that's another question. I don't know whether there is a coalition, or it is just Aubrey, a bit of support base there for Aubrey. Maybe the party should just be renamed the Aubrey Little Group, and then it is what it is, Aubrey's Little Group. And then we have to decide whether that is what we want as a people, whether that's going to be able to take us across the finish line in seeing the backs of the PPP regime with what we see here right now being passed off as politics. So let me see here. Rishram Ramcharan is saying, Mark, you do not know what you're talking about. The PNC, AFC, WPA have no integrity. Just like that, right? You tell me who in the PPP, Rishram, who in the PPP right now leadership that has integrity? You tell me. You think Bharat Jagdeo has integrity? You think Irfan Ali has integrity? 19 fraud charges. The Canadian blocked him from going to Canada. Don't worry, because he has a little opportunity because of the Geneva Convention that allows head of state, regardless of how they're in office, to travel. But you tell me, Bharat has integrity? You think Bharat has integrity? Irfan Ali, 19 fraud charges, has integrity? He can't tell you where he graduated with his first degree or where he did a supposed master's and these sort of things. And you're talking about integrity? I don't know, Rishram. Rishram, I give you that opportunity to respond. In the meanwhile, I'll give you some pointers in which you can probably take, and then you respond. Hopefully Sue is watching.
Source. Okay, well, maybe the Chinese company that did not get the agreement that they wanted here, maybe they're the ones who told you, or it could be just a fictitious thing.
Okay, well, let's talk about specific individuals. What is your relationship with Mr. Sue Jerome?
Sue? Oh, Sue. My relationship? Nothing. He's a tenant in my place, yeah.
And he's a good friend of yours?
Yes, yes. He is a friend of ours. His father was here from many years ago.
Mm-hmm. I mean, he lives next door to you.
Yes.
You know, he was able to arrange meetings and catch-ups with you at any point in the day. He claims
as a friend, yeah.
He claims that through his very close relationship with you, he's able to get any deal done.
Well, I don't know if that's
able to change laws for investors.
But then which law has been changed for any investor?
So Sue told us that if you want to get anything done in Ghana, you need some hookups.
Rishram, you think he has integrity? Here it is that a businessman, a Chinese businessman, is accusing him. And that's not a media house that interviewed him, a local media house. That's an international media house. Vice News interviewed him. I guess you're going to say that Vice News has an agenda, right? But Rishram, it's Navratri, right? Happy Navratri to all our Hindu brothers and sisters. But you're saying here, Mark, you do not know what you're talking. All right, let us say for argument's sake, I don't. Do you think you know what you're talking about? Here's what a Chinese businessman is alleging, that he bribed Jack Deo. And this is not the first that we're hearing about these things, about Jack Deo and corruption and all these manner of things. It's not the first. Lots and lots of corruption allegations we've been hearing about. Hundreds of millions of dollars in foreign accounts. They said that Bornham, forget about Bornham, had this guy, Jack Deere, ask Jack Deere Rishram whether he has an account in a bank of somewhere in China under a different name. Ask him these things. Look at Irfan Ali. You think Irfan Ali born with a gold spoon in his mouth? And look, even when he became the Minister of Housing, look at all the things that they own. Look at all of the properties and the lands and all these different things. You think this is propaganda? Rish Ram? And now, Rish Ram, I'm being very respectful because you're entitled to your view, your opinions, and I think you are asking something in a very respectful manner. You're not going on like some of the others and cuss up and go on as if the bombs raised. And I respect this fact. I may disagree with you. It doesn't say that all of them in the PNC, AFC, WPA are angels. They got some vagabonds in there too, right? But not all of them are the same. But I'll tell you this, the bulk of them guys in the hierarchy of the PPP are a bunch of bandits, bunch of crooks. But, don't speak of integrity and who in the PNC, AFC. Come on, respond to me before I move on. Rishram, nice name, by the way. I guess they call you Rishi for short, or Rami. Ram. All right, Rishram, let's see what some other folks are saying. Enough of Rishram for now. He's not going to return because I would have reminded him exactly what Sue said. Let's go to Sue because we're still looking for Sue, right? How long have you been living at Jack Deo's house?
No, the people just, I don't know what them doing. They never do nothing there. You understand?
Yeah. So how long have you been living at Jack Deo's house?
Huh?
How long have you been living at Jack Deo's house?
Hello?
Yeah. How long have you been living at Jack Deo's house?
For 1 year now.
Okay. So how much rent do you pay every month?
I pay 1.2.
1.2 million Guyana dollars?
Yeah.
Now when Vice News interview you, did they put you on camera?
No.
Did they record you?
I don't know nothing there.
Okay, so do you know?
I don't know what them do it.
Oh, so you don't know?
No, I don't know nothing there.
So why would they lie? Why would they lie on you? Are they lying on you, Mr. Sue?
I don't know why he lies for me. Them people claim to place. I don't know. It's no true. I tell you, 100% no true. They not think this. You understand what I said?
So did you, when you met with Mr. Jack Deere, because he met you, he called you over, what did you guys discuss?
No, just the people come invest in Kerala. So that's it.
So, and you issued a statement. Who wrote the statement for you in English?
I get the translator. Okay?
I got you. So who? Let me ask before you go, Mr. Su. Before you go, the APNU coalition government. Did you have a good relationship with them?
No, the people is pain, I don't know nothing for that. You understand? I in the Lord, I told for
So, Rishram, you got to be careful. And remember, Rishram and others, that it was the PPP and their supporters who were accusing the coalition of rigging the elections and that the SOPs were bad. Now, let me just break this down, as I usually do, Rishram, that for almost 3 years now, the PPP was actually installed into office. How is it that the PPP, Jack Teo and Irfan Ali and the likes and those goons in the private sector commission, how is it that they're not eager about exposing the coalition via their SOPs? The PPP has possession of those SOPs. You're telling me that they couldn't find a way through Eclipse and others to expose those SOPs? You're telling me that the PPP is such an angel that they wouldn't find ways to expose the SOPs? You're telling me that the PPP would not want to allow the elections petitions to be heard in the courts so that everybody's SOPs will be exposed and opened up and revealed for the world? One simple question, Rishram and others. Isn't it suspicious that the very PPP, Jack Deo, Irfan, all of them that were standing on top of empty barrels, making a bunch of silly noises about SOPs, isn't it strange that the very PPP, the very folks in the PPP who are bawling out SOPs, don't want you guys, ordinary supporters, to see those SOPs? It is not now for the coalition to show their SOPs. Everything is in the regime's hands. Everything is in the PPP's hands. Rishram and others, do not be fooled nor brainwashed by these knucklehead politicians in the PPP. They're fooling you guys. They know that the elections were actually rigged in their favor. They're well aware of these things, but they don't want you guys to know the truth. But I'll tell you guys the truth. The truth is they have rigged the elections with friends, non-Guineanese friends. They have rigged the elections. And the funny thing is, maybe it's not that funny, that the coalition, those in the coalition government at that time, were busy fighting amongst each other during elections time. Who in talking to who in doing this, who in a bunch of Jim Cockburn Ramgoat story during elections time. They were all over the place. They were fighting each other internally, but they weren't paying attention to the snakes creeping up on them. They weren't paying attention to the snakes creeping up on them. Maybe some of them were even in bed with the snakes who creeped up on them on elections day and started to bawl. Rig. It was all planned. It was all set. And now let me ask you this, Richram. And let me ask you, and I didn't really mean that last part when I said Rigram, sorry, because you haven't done anything for me to disrespect you. But let me ask you this question. They rushed and they charged, PPP. They rushed and they charged these three persons along with others, but these are more known than the others. But we still have those others in our minds who were wrongfully charged. You got Lowenfield, Keith Lowenfield, Roxanne Myers, and Mingo. Now, going on 3 years now, every time these folks appear in court, the prosecutor or persecutor or prosecutor, whichever one you want to choose, it's fine. I may choose two of the three, and it's not one of them is definitely not one, not the prosecutor I will choose in describing what is happening to these folks. But every time they appear in court, the prosecutor not ready, the magistrate giving them more and more time, the prosecutor that is, and they're wasting these people's time. They're persecuting these people because the truth is they do not have any evidence at all to prosecute these people. And instead, they are persecuting them for almost 3 years now. And I want you guys to remember the names. Maybe we will print t-shirts with them with their faces on. Remember the name. Keith Lowenfield, Roxanne Myers, Mingo. They are being persecuted by the PPP regime because there is no evidence that these folks, at least I have not seen, and I know the general public have not seen, any evidence against these people. And we don't have to all go to university or college or whatever to understand the propaganda and how the PPP wants to brainwash people. But they're not going to brainwash me. They're not going to sell their propaganda to me. And I know most of you guys have rejected the brainwashing or the propaganda. Right, Rishram? Now let's hear what this former diplomat has to say. Lawrence Houston. Good evening to you, sir. The PPP should show the SOPs they have in their possession to show they won the elections. Those SOPs would show the signatures of all the agents representing those parties who participated in the elections. Most importantly, it must show those representing the APNU AFC to even to be considered as authentic. Good. Lawrence Houston, former diplomat, is saying that. And the question is, why again? Thank you, Lawrence. Why is it that the PPP is so afraid right now? Not the coalition, not the APNU, not the AFC. So instead of the PPP having a little idiotic individual walking around with horns and hollering at Aubrey Norton, we want to see your SOPs. We want to see your SOPs. Aubrey should just walk around, raise up his short jacket and whine like a Buxton Euro, right? And because that's a little bit of humor, right? But it's how these Nimakarams in the PPP behave, as though all of the people who are watching this show went to IFLAT University, like you know who. So thank you so much, Lawrence, and hope all is well with you, sir. Now back to these folks, and I'm trying to break it down as it's breakdown morning. Because when people come with foolishness, we have to address them. And some folks may say, Mark, no waste time. You see, that's the problem. They come with foolishness, but we must be so proper and we must ignore them. Oh, Mark, no waste time with that one. No waste time with the other one. Now we got to break it down for some of these guys. We got to break it down. Now, again, and I have said this before, if they present evidence in court that these folks have done something wrong, and I see the evidence, there is no need for me to support them at all, period. But when there's no evidence presented in court, now what the PPP say? What the PPP say is not evidence. And nobody would want to listen to what the PPP say. Because look who is saying it. Because Jack Deere said that means it's true. Jack Dare, if he didn't get into politics, Jack Dare would have probably been somewhere on Unity on the East Coast kicking Catmarant. Let me see how many of you guys know Catmarant. Or he would have been working as an undertaker at Sandy's funeral home. That is where he should have been. I'm not saying he should have been inside Sandy's funeral. You know, again, you guys are something else. I'll be back in a second. All right. I just had to take that quick break. We will be joined by Senior Counsel, Member of Parliament, Mr. Roysdale Ford. We will be joined shortly. So, you guys don't go anywhere. We want to find out exactly what happened there. And again, I'm not a lawyer, and I'm not going to pretend that I'm a lawyer, but we got to hear from the experts. And sometimes you got to put your hands up and say, let the experts take over, right? There's nothing is wrong with that. Let the experts take over, and the experts are those who were part and parcel of the case moments ago. Roysdale Ford, we will be joined by Mr. Roysdale Ford, and we will hear exactly what transpired in legal terms. So, yeah, sorry about that. So let's continue in terms of breaking this thing down. I see there is Mr. Houston is saying thank you, Mark. You're welcome. You're welcome. The PPP must be held accountable to their own statements. That is true. They assert the coalition SOPs are false. So let them prove it by showing what they think are the SOPs. That's correct. Thank you so much, Lawrence. Let's head straight over to Guyana. And we are joined by the Senior Counsel, Mr. Roysdale Ford, also a Member of Parliament. He has been on the block for a while. It doesn't mean that he started off very young in the legal profession. He was there in the 1997 elections petition case as well. And that took 4+ years before it was vitiated, and new elections were called in March of 2001. Good morning, Honorable Senior Counsel. How are you, sir?
Good morning to my friend Mark and to your viewing and listening audience.
Thank you so much, sir. Am I correct? 4+ years the 1997 elections petitions took?
Yes, Mark. That took 4 years to be heard. That was delivered. This judgment was delivered by Justice Claudette Singh, who's now the chairman of the Elections Commission.
And that there was basically one piece of information that the then Justice Claudette Singh ruled, and they had to call election compared to what we're seeing now. What's happening then? And did it surprise you then, as a young lawyer, that it took an elections petition took 4+ years, sir?
Yes, Mark. It was a very astonishing experience. The PPP haven't changed much. The delaying tactics then and now are the same. The efforts to suppress the will of the people are the same. I recall in the 1997 elections petition, the superior election petition, the PPP calling witnesses after witnesses, trying to draw it out over an extended period of time. There were months where there were no hearings taking place. So what we're seeing and the maneuvers being employed by the PPP is not new, nothing new, Mark.
Absolutely,
as you would recall yourself.
Absolutely nothing new indeed. But I want to ask a question as it pertains, because we see other parts of the world, elections petitions are held expeditiously. Is there nowhere in the Constitution that says that? I know the CCJ, one of the justices actually alluded to elections petitions being heard expeditiously. Your thoughts on why it's not?
Mark, the elections laws the election laws that govern the conduct of the election petition and the hearing of the elections petition, the National Assembly Validity Election Act says it must be heard day to day. That is the reference to the urgency as stated by the legislation. But what you asked, Mark, is a very important question as we move towards this period of constitutional reform, as stated by Nandalal. You know, we can't take his word and the PPP's word for anything, but they said that they want to have constitutional reform, and I believe that that is one of the areas that we must have a serious review. Mark, you would have seen the election results in Kenya. I hope you were following it. And you'd have seen that it was very disputed, very contentious, but it was heard and determined by the Supreme Court of Kenya in a matter of less than a month. The reason for that, Mark, is that they took a different position in their constitution. They said that whoever is declared to have won the election cannot be sworn in as the president until it is heard and determined by the Supreme Court. So rather than starting in the High Court, and then you appeal to the Court of Appeal, and then you go to the CCJ, their elections petitions are heard by their highest appellate court. The party that is presumed to have won the election cannot be sworn in. They remain a president-elect. After those matters would have been heard and determined, then a swearing-in process takes place, an inauguration takes place, and a new government is formed. So I believe that we need to have serious constitutional reform dealing with those issues and the expedition of the hearing of an election petition. Apart from that, Mark, we also need to deal with the travesty that emerged in Petition 99 in the appellate process, in which the CCJ ruled effectively that you can't appeal a dismissal of an election petition. All those issues would be obviated and rendered completely unnecessary if we identify a court that is the sole court to hear and determine an election petition expeditiously.
Absolutely.
Because the current system, Mark, sorry.
That's okay, go ahead.
The current system is definitely not working effectively, Mark.
It is definitely not working effectively. Before we go to what transpired today, I want to ask you with regards to the discussion that I've had earlier as it pertains to SOPs and the fact that PPP and their supporters have been basically beating up on the coalition for not showing their SOPs. Now, here's the opportunity for the PPP to allow these elections petitions to be heard without rushing to file appeals upon appeals and so forth. Is there something sinister within the PPP why they don't want all those SOPs to be exposed? Something with your volume. Your volume. We can't hear you, sir.
Someone was trying to call me there. I'm sorry about that.
That's okay.
Could I speak now?
Yes, sir. Go ahead.
Mark, the SOPs are the first thing that the SOP is completely irrelevant right now, Mark, in the context of what was the basis upon which the elections would have been determined on. As I pointed out in my presentation to the court a few minutes ago, it was determined on the basis of a national recount that was in itself not only unconstitutional and unlawful, but itself was the manifestation of fraud. You saw, the public saw, the country saw the numerous ballot boxes, 47 ballot boxes that had no statutory documents. We were able to identify and to present to the public's notice, and including the diplomatic community, the fact that persons who are either dead or overseas were recorded and actually were recorded as voting. So the PPP wants to speak about the issue of SOPs. But the SOPs, Mark, is another manifestation of, in their constituencies that they control, of the fraud that took place.
Absolutely. SOPs is a manifestation of the fraud that actually took place. And as I have been breaking it down to their support base, and the question is, why do they suppose that the PPP is so reluctant to open up the SOPs for all to see? That's just the question. Let me get on to what transpired today, Mr. Ford. And for those who are now joining us, the appellate court just wrapped up a session there, and Mr. Ford is here to offer some explanation as to what transpired today with today's case. Break it down for us, please, sir.
Well, Mark, today's case, we argued fundamentally that the issue of Section 22, which is of the Election Laws Amendment Act, the act that provided for the basis of the creation and introduction of Order 60, upon which the election recount process was conducted. We argued today that it was unconstitutional, that Section 22 was unconstitutional, as the power to conduct and to provide for an election was specifically provided for in Article 160 of the Constitution, which gave that power only to Parliament to pass laws. So what would have happened, Mark, is that in an effort to get around that, Section 22 was basically used by GCOM to ensure that Order 60 was put in place to conduct a recount. Our argument before the court was that the only authority vested with law and their power to put any electoral mechanism and legal system in place was Parliament. And when you look at Section 22, it did not provide what is to happen. What are the details to happen? Even if there's a difficulty, as the section says, what is to happen, what is to be done, how it is to be done. And those are important matters that ought to have been provided for, firstly, by the Parliament itself. And then we're also saying that the law itself, it has purported to give and divest Parliament of that essential power to determine and control electoral systems should have been determined by Parliament and not by GCOM. Because in effect, what you have happened here, Mark, was that the system upon which the 2020 elections were determined were established after and in midstream of the electoral process. Imagine in a game of cricket, Mark, you suddenly decide that what you hit as a 4 is now a 10. And that is essentially what happened. And GCOM, being the umpire, changed the rules, intervened in the electoral process, and materially altered the requirements of a law that governed the execution and holding of the elections, other than as provided for in the Representation of the People's Act. So let me try again, Mark, one more time. Basically, today we told the court that Section 22 is no good. It took away the power from Parliament, placed it in the hands of the Elections Commission, which fundamentally, in the context of our electoral system, is three government, 3 opposition, and a chairman. So you basically establish another political body in which they will determine the outcome of a process that is supposed to be rendered and controlled and determined by people who are not politically aligned.
So after today's hearing, the court will render its decision. Did they give a timeline?
No, Mark. The court didn't indicate a timeline. The court said that it will send notices when the decision is ready.
Okay. I've heard, we have heard that the lawyers for maybe the regime and so forth, they argued that they didn't receive copies of submissions from you. Your take on that?
That is a complete non-issue, Mark. The submissions were emailed to them. What they were complaining about is the references to certain cases, which they claim, I still have to confirm that they weren't delivered to them. I'm not prepared to take their word that it wasn't sent to them. But even if it wasn't sent to them, Mark, I believe that that is a most minor issue. As I indicated to the court, they could have indicated to me months ago, Roysdale, you know, you send these submissions without the cases, as had happened before. I've done it to council. Council have done it to me. You didn't send me the submissions. You simply go and press send. So to wait today to make that an issue doesn't take the matter far. It does not impact on the issues to be determined by the court. And as I indicated to the court, with minimum effort, these are cases that could be found online. If you type in the names of any one of them, they pop up. Counsel know, especially experienced counsel like Mendez and Astafan, you have massive chambers. You could easily have found the case. And the issue really shows that maybe they didn't want to read the cases and they didn't want to respond to them.
The usual nitpicking on very simple things, another indication that they're really afraid of the elections petition cases. What's happening overall? There are two petitions. Can you explain to our audience what's happening with the other?
The other petition was dismissed. The appeal that we filed from the Court of Appeal to the CCJ was dismissed because the Court of Appeal ruled that we had a right of appeal from the dismissal of the petition, and the CCJ, on an appeal by Nandalal and his group, the Court of Appeal, CCJ ruled that there was no right of appeal. So that petition came to an end effectively.
And so we only have this one elections petition that is currently being heard in the appellate court.
Yes, ma'am.
Okay. How optimistic are you that the opposition will get somewhere with this elections petition after your commendable arguments made earlier?
Oh, thank you very much, Mark. And the commendable arguments, I delivered them, but this was a result of a team, and I would like to publicly acknowledge the work and the contribution of Senior Counsel John Jeremy of Trinidad and Tobago, former Attorney General, and the work and contribution of Selwyn Peters, who has been with us every step of the way, dark hours, working to prepare the sort of presentation that we made today. So it's a team effort, as most things should be. We need to coordinate, act in unity, and move things forward. In relation to the issue of my estimation of success, I believe that we have put in the work, and we now simply have to wait to see what would be the position of the court.
So this is for example, and I don't want to be pessimistic. I'm not a pessimist, but I'm hoping that it will be in favor of the people, meaning that this case can be another winning case for you and your team. But what if it ends right here? That's it for all of the elections petitions. Obviously, it's done with.
No, Mark. Okay. No, you can't appeal. The difference between this petition and the other petition is that the Chief Justice, in relation to Petition 99, did not allow it to proceed to a hearing and dismissed it. So that was the basis of the appeal to the Court of Appeal. The Court of Appeal said, yes, when the petition is dismissed without a hearing, a formal hearing in the High Court, you can appeal to us. The CCJ says no. This one can go on to the CCJ, even if it is dismissed by the Court of Appeal.
Got you. Thank you so much. Sorry, go ahead. Yeah.
Because of the substantive decision made by the Chief Justice in the High Court.
Thank you so much for that. So at least it gives a breakdown so that people can know where it stands. Senior Counsel Roysdale Ford, also Member of Parliament. He is just here to explain what just transpired. I know you guys want me to interview him on other matters, maybe on another occasion when Mr. Roysdale Ford has some extra time to spare us on Straight Up. I'm extending an invitation to you, sir. I'm not sure when you're available, but you know our door is always open for you guys in the opposition there. Is there any other thing?
Yes, Mark.
Is there any other thing you want to? Sorry, go ahead.
Yeah, I want to take the opportunity to thank you for airing the program live. I wasn't aware that it was being aired live, and you had made this time available to put the matter in the public's domain for them to understand what is happening. When I came offline, Selwyn told me that he saw that it was going live. And I think it is very commendable, and I thank you for your continued commitment to the cause.
Thank you so much. Commitment for the cause indeed. Mr. Senior Counsel, also a Member of Parliament, Roysdale Ford, giving us a breakdown on the just concluded case in front of the Guyana Court of Appeal. A decision will be rendered hopefully shortly. Usually, what's the time frame, Mr. Ford, with regards to these decisions?
Mark, you really can't say. Sometimes the court comes back within a month or two. Sometimes they take a bit longer. It's hard to tell, really.
It's hard to tell. You have lots of folks listening to you in Guyana, outside of Guyana. Is there anything else you wish to say in parting for today?
Yes, Mark. I would ask the faithful, I call them the faithful, because of their continued commitment and support. whilst they demonstrate the continued commitment and support when I meet people all across the country. Yesterday, I had extensive discussions with the ordinary Guyanese who was very concerned about the work of the party and what would happen today. I went into the countrysides, and it was quite interesting to know that they're interested in elections petition. They're determined to ensure to see the back of the PPP. And I believe what is essential now is that we remain vigilant, we remain focused, and not to be carried away by the gimmicks and tricks of the PPP under any circumstances.
Absolutely. The gimmicks and tricks. Yesterday was Anti-Discrimination Day. I noticed the PPP issued a statement, kind of like hypocritical indeed. The police didn't grant permission for a march that the coalition, I heard that the coalition plans, or APNU, PNC plans some march. The police denied that. As a lawyer, and you are an experienced lawyer for all those years, does that concern you at all that the police is acting in that manner?
Yes, Mark. I believe that decision by the police is not only unlawful, it is a breach of the constitutional rights of the persons who wanted to have the march, my party that wanted to have the march, and there's no legal basis for that sort of behavior. It's another manifestation of the unconstitutional, undemocratic nature. The right to protest peacefully is enshrined in the Constitution. It's part of your freedom of expression.
I know you're running just off of this court case. Today's Wednesday. You still have some more court matters. Just 2 or 3 minutes more of your time. Can you say in the Constitution it gives people the right for freedom of assembly and so forth? And the fact that the PPP obviously is doing the political bidding, in my opinion, of the PPP here, denying such a right. What legal remedy can take place so that that can be addressed?
Well, Mark, I would need a little opportunity to explain a couple of things, if you would permit me.
If you have the time, go right ahead, sir.
Fourth, Mark, the Constitution, the 1980 Constitution, specifically provide that citizens of this country have the right to freedom of expression, the right to peacefully protest. The laws that govern and require permission from the police are laws that predated the Constitution. So in the Commonwealth Caribbean jurisprudence and constitutional laws, issues that arise, there are ongoing issues in relation to the impact of these sort of pre-colonial, pre-independence laws, the colonial laws, and the impact they have on the breadth and extent of the rights of citizens. Recently, the Caribbean Court of Justice struck down, I can't remember which law it was, but a number of laws that predate the Constitution, and the courts have found, the CCJ has found, that those sort of laws impact on the freedom of rights that are actually enshrined in the Constitution. So I believe that whilst we have to probably press ahead on holding these sort of rallies as a source and a manifestation of our determination to hold them, we also have to not rule out the possibilities of instituting legal proceedings challenging these things that will break the sort of institutional authority over these type of matters. Those are issues that I will certainly take to the party and to ensure that we have a pathway forward in terms of how we could deal with that.
You know, Mr. Ford, knowing that the police is doing the biddings, obviously, of the PPP, what if you guys had gone ahead with that march? Would it have been illegal since there was no permission granted by the police?
Mark, the government and the police would have said that the march was illegal because they would have been acting under a purported law which indicated that, yes, you needed to have permission. The issue of the legality of the march would have been an issue that would have arisen during the potential charges. We're anticipating charges. You understand, Mark? We're anticipating that people would have been charged. Those issues would have been raised or ought to have been raised by counsel at the magistrate's court. At the magistrate's court, those issues automatically would have to be referred to the High Court for determination. The charges would have had to be suspended until the those issues are heard and determined as to whether the people really and truly were charged under a valid extant law. And I'm just trying to map out where we could have gone in those circumstances.
And it is not something that is so new to Guyana. You have represented me on quite a few cases where they charged me for illegal protests, Lincoln Lewis and others.
And you got off, right, Mark? And you got off.
And yeah, on the basis of my constitutional right. Yeah. Continue what you guys are doing there. I see you're busy all over the place. Is there any other big case that's coming up? I know I spoke about these individuals who their matters are not being heard at all, but yet they have been dragged before the court for almost 3 years now. We have a Trevor Penn. We have all these matters here. In my opinion, these folks are being persecuted. Quickly before you go, your take on why these matters are just languishing in the magistrate's court.
Mark, I'm not counsel in these matters, so I don't want to get into the nitty-gritty as to why they may be still in court. I know they're being represented by a superb lawyer, Mr. Nigel Hughes, and I know that he obviously will be watching and planning. But as to why they remain in the court, I could certainly comment on that. I believe they have no evidence, absolutely no evidence. And this is about simply parading persons and destroying their character, especially in the context of them being African Guyanese and the perception that is being pushed by the government of the certain view that must be held of people of African Guyanese descent.
I guess we'll end it at that. We'll agree with you that exactly the agenda of the PPP is to go after persons of African descent by every and any means necessary. Mr. Ford, thank you so much. I appreciate your time. Give my regards to the other 30.
Thank you very much, Mark.
Thank you so much, sir. Good. Senior counsel there, Roysdale Ford, breaking it down for us. And with that breaking down, I'm just not going to add anything else other than to remind you guys about this. 61 dead voters, 4,864 absent voters, 150 stuffed ballot boxes, 47 ballot boxes without documents, 1,278 missing oaths of identity. And then we're reminded what Lincoln Lewis said. What electoral democracy? 47 plus boxes without statutory documents, plus electoral malpractices? Only the lawless applauds lawlessness. Well said, Lincoln Lewis. I'll be back this evening. I will be back this evening. 9 o'clock, right here on 107.1 FM. Thank you all so much for listening from the Bronx, wherever you're listening, Brooklyn, wherever. And thank you, Senior Counsel Roysdale Ford and former Attorney General of Trinidad and Tobago, Jeremy, and also Attorney at Law, Selwyn Peters, for their arguments in today's case. So, all right, see you later this evening. Until then, continue to be safe in every aspect. And remember what the regime is doing to persons of African descent, right? Remember that. Oh, before we go, take a look at this situation here with a baby at a daycare. My condolences to the family members. Take a quick look at this, please.
Mother. So mother sent to the daycare this morning. Okay, everything all right. And got called that she unresponsible. She had to go in the daycare. But she got daycare, the ambulance pick her up and bring her here unresponsible. Dead on her right now. That's what I know. And I come down here with she to know that the last will last. That's what I know.
How old was the baby?
Maybe 7 months. 7 months old. This man left everything good, no problem. She left normal, smiling, everything okay.
I was made to understand her more than my daughter. She fall and decided to bed in the daycare and she wrap up between the sheets and some kids. So by the time they're gonna call me to calm down, she arrived at the health center unresponsive. By the time they could bring her to Georgetown Hospital, She was pronounced dead on arrival due to suffocation. Pardon my daughter.
And as a parent, very sorry to hear, man.
How can I take her be so irresponsible? Well, let me try to fall and suffocate. Oh. How this possible?
Marissa, you taking me for a drive?
Like when this thing happened, it took 2 hours before they could get to me. Why did it hurt? Why did they rush it to the hospital and didn't set up the health center? Why?
What would you like to see happen after now?
Justice.
You need proper understanding really go on at the health center because baby just don't go health center to the daycare and you don't go to the daycare just come back sick, come back dead or rush for stabbing for bread just so. She had a minor cold but not a cold for thing. Cold don't break, she don't cold don't so that cold is no excuse for
first thing the daycare lady deprived me entrance to see how and where my child is doing well. Telling me about child care has come every day to inspect. No need for me to come in.
That's the reason I allow she for
but assure me that in safe hands. But yet
I go to the daycare the
one
father.
Day she came home with a boogie on her head. When I inquiry, child know your child in safe hands. Deny me entry to see how my child is doing well. When people find out today, the child falling and then side of the bed on the ground. Suffocated between the sheets. Oh! How the chicken could be so careless? Oh!
This is which daycare you're talking about? Olga daycare. Alright.